Yes, ready, go. Their suit for partition having been decreed by the trial court but reversed by the High Court in a regular first appeal, the plaintiffs have come up with the above appeal para. We have heard Sri Dushyant A. Dave, learned senior counsel for the appellant, and Sri Thomas P. Joseph, learned counsel for the respondent para. The suit scheduled property originally belonged to one Narayan Wagh. After his death, the property devolved upon his two daughters, one of whom is the appellant herein. The appellant herein executed a general power of attorney on 21/7/1971, registered as document number 35 of 1971, in favor of her sister Srimati Rani Siddhan. However, the said power was cancelled on 31/1/1985, but in the meantime, the appellant's sister was found to have executed four different documents in favor of certain third parties, assigning, releasing some properties. Therefore, the appellant first filed a suit in OS number 16 of 1986, followed by another suit in OS number 27 of 1988 against the assignees oblique releases, though a preliminary decree was passed in the second suit on 7/1/1989. The appellant came to know later that the assignees' releases had sold the property to the respondent herein para. Therefore, the appellant filed yet another suit in OS number 130 of 1989, seeking partition and separate possession of her half share in the suit property. The trial court granted a preliminary decree in favor of the appellant. However, the regular appeal filed by the respondent herein was allowed by a division bench of the High Court by the judgment and decree impugned in this appeal. Therefore, the appellant has come up with the above appeal para. At the outset, it should be stated that the respondent herein did not dispute the fact that the suit scheduled property originally belonged to the father of the appellant and her sister, and that the appellant and her sister were entitled to equal shares in the property, but respondent contested the suit on the grounds inter alia that in view of two prior suits for partition, namely OS number 16 of 1986 and OS number 27 of 1988, the suit was barred under Order 2, Rule 2 of Civil Procedure Code, that the general power of attorney executed by the appellant in favor of her sister authorized the agent to sign all documents and present them for registration, that by virtue of the said power, the appellant's sister transferred the suit scheduled property to four persons for the purpose of discharging the debts incurred in the family business, that those transferees discharging in turn sold the property to the respondent herein for a valuable consideration, that though the appellant was earlier residing in England, she came back to India and was staying in a house just 1 kilometer away from the plaintiff's scheduled property, that the appellant was therefore aware of all the transfers, including the transfer in favor of the respondent and the development made by the respondent over the suit property para, that therefore the appellant is guilty of acquiescence, and that the respondent has actually developed a commercial complex on the suit property and hence entitled at least to the value of improvements in the event of a decree being passed. Para. The trial court framed as many as 23 issues for consideration in the suit, that the objection on the basis of Order Roman II, Rule 2 of Civil Procedure Code was rejected by the trial court on the ground that the appellant's sister had committed a fraud and that the cause of action for the present suit was different from the cause of action for the previous suits.